Welcome to the Don't Be Scared, Be Prepared. This is our first session. And before we actually start, there's some housekeeping chores that I want to finish and just let you know about. You all have been given evaluation forms. So one very important way for us to know how we are doing is by you telling us what you think about each session. So if at the end you can fill out, and they're really simple because they're only yes or no answers. If you can just fill out what you thought of this session, and as you go out, we're going to collect the evaluations and the pencils. We will greatly appreciate it, and we'll keep you informed along the way how the evaluations go. Also, some of you may begin to feel a little overwhelmed that there's so much information that's coming out in these sessions, and you may begin to wonder how you're going to remember it all. Well, don't feel that you have to write everything down, because you don't. Because what you can do is go on to channel 919 or 918, because every session is going to be taped on television. So you can go back and review it at your leisure, and you can also allow your family to watch it also. So you can devote all your attention to the speaker and not have to worry about writing things down, because things will get lost in the translation for you. The other thing that I want you to know about, and this is very, very important, all of the content that we talk about has really been prepared with all of you in mind, and we do it to the best of our abilities and the best of our expertise. But questions, you should always know that it is important for you to also check with your doctors or with your attorneys or other people in the healthcare profession as you see fit, because our sessions are really informational and they're not legally binding. Also, we have a chaplain, an intern, Denise, who is serving as a liaison to you in our Don't Be Scared program. Denise, who's in the Pastoral Services office, is helping people prepare for end-of-life issues, and she would be absolutely delighted to speak with you. So you can contact her, Denise, in the Pastoral Services office. And every month, remember, it's on the third Monday of every month. It's on your events calendar. So keep checking the calendar. It's the same time, 12:30 to 2, and it's in the catering room. But today, most importantly, I want to introduce our two wonderful speakers, Nancy Earsy, who is also a resident of Brixby, and Jim Peterson, who is a practicing attorney. And they are going to lead you in their discussion today. So all of you, my friends, join with us, sit back, and relax. Thank you.
Carol did not introduce herself, but that was Carol Bortman, for those few of you who may not have met her yet. And you can see what a terrific leader she is in helping harness the talents that put this together. So it's great to be here today. I am Nancy Earsy, and I want to say a little bit about our fabulous lawyer speaker today. Attorney Jim Peterson is a graduate of Boston University Law School. He has been engaged in private practice in Salem since 1977. His specialties include elder law, and he is a member of the National Academy of Elder Law Attorneys. He also focuses on estate planning, probate, and estate administration. So you see, we have the perfect person to talk to us for this very first session. I should mention he's also a member of the Massachusetts Bar Association and the Salem Bar Association. He's no stranger to Brooksby Village. His parents were residents here, and he has clients who are Brooksby residents as well. In fact, rumor has it, he even makes house calls, just to know. So, like the other speakers in the Be Prepared lecture series, Attorney Peterson has volunteered his time and to share his knowledge and expertise with us. He will give us an informational overview of the legal procedures, documents, and issues involved in estate planning. He will not give specific legal advice to individuals in this presentation. The overall goal, as Carol mentioned, is this whole series, which will be month by month for a whole year, dealing with different aspects of end-of-life issues, planning, medical issues, and things that we need to know to make good decisions for ourselves and our families. So this session is about estate planning, and Jim's presentation will focus on how to get the help we need from attorneys, accountants, and other professionals so we can plan our affairs and our legacy for our families and the world. So, Jim, it's yours. Take it away.
Thank you, Nancy, and thank you, Carol. And I'm really impressed at seeing the plans for this program and at what's coming up. And I'm a little nervous about being the first speaker. I hope I can start things off well. As Nancy says, the old joke, I've been practicing law for 40 years, and I'm going to keep practicing till I get it right. Brooksby is a great place. It was a great place for my parents. They lived at Orchard View Court, and I'm thrilled to be here and to be able to help all of you in thinking about your futures. As Nancy says, this is just a basic introduction. This is just a basic introduction. We have a lot to cover in a limited amount of time, so I will do the best I can. We are trying to save a little time at the end for questions. What we're focusing today is on the people involved in estate planning, and two categories of people. One, the people who are going to help you and represent you, do the work for you, and the other category is the people who will benefit. And I want to try to get you thinking about both those categories, try to focus your minds on that. Next month, on December 17th, we will talk about the documents. So today is people, and to get you thinking about the people who you want to manage things and the people you want to benefit. Next month is the documents and how you do that. First group of people who are involved in estate planning is professionals, and I'm just going to briefly say, and you have on your outline, there are some groups of professionals who you may or may not want to involve: financial planners, accountants or tax advisors, and professional fiduciaries. And you're going to learn the word fiduciary today if you don't already know it. We'll be talking about that. I'll define that in a moment. In terms of professionals, think about what you need. If you can manage everything yourself, if you're comfortable, if you have the knowledge and the time to manage all your own investments, that's great. If you need more advice or tax planning, you may want to go to a professional. Or you can also go to a trust department of a bank or something like that that will handle everything for you. You decide how much you can do yourself and how much help you need, and look at the appropriate professionals to help with that. You can also, of course, go to an attorney at law, and that attorney at law is important. I'll be using the word attorney differently in a moment. For any of these professionals, to me, how do you find the best professional in anything you want to do? Whether it's a lawyer, a CPA, a doctor, or a plumber, find a friend, someone you respect, who has had a similar issue. See if they had a professional who they were happy with. Start off there. Do some research yourself. Look online, look at professional organizations. But finally, also meet with the person and make sure you're comfortable with them as a person and you're able to work with them. Some people may be great at things but may not communicate well with you, or vice versa. The next thing when you get beyond professionals is in your estate planning, you will be looking at people, non-professional people, or sometimes professionals, who are going to help you. Now on my outline I say who with an M around it. Who do you trust? Do we have any English teachers or English majors here or librarians? Who thinks it should be whom do you trust? I got a couple there. Who thinks it should be who do you trust? Well, there weren't too many opinions, but the whom wins. Okay, so whom do you trust? You're going to be looking at a fiduciary. And I tried to figure out, it's a word that I use regularly, but I went to law school and I've been a lawyer for 40 years, so I sort of know what it means. But where do you look for a layman's definition of a fiduciary or anything else? The first source these days is Wikipedia, which is the ultimate authority on everything. So I have a quick definition there, which is a good one. A person who holds a legal or ethical relationship of trust. And then another source for something like that is Black's Law Dictionary, which is a big, thick book you have to pull off a shelf and open up and get the definition there: a person having a duty to act primarily for another's benefit. Regardless, the key word is trust. When you are choosing the people for the positions I'm about to talk about, you want to choose someone who you can trust to make the right decision, and in some cases to make the decision that you would make if you were able to make the decision yourself. So you're choosing a person or a business who you trust with your decision making when you get to the point where you can't do it yourself. There are different categories of fiduciaries, and I'm going to group them. The first category is people who help during your lifetime. And the first fiduciary position for that would be, the legal term is attorney in fact. Remember a moment ago I said attorney at law? An attorney in fact is a person who you name in a written power of attorney to represent you. An attorney at law can represent you in court. An attorney in fact can represent you by signing your name to legal documents. Now, people often refer to that person as a power of attorney. In my legalistic mind, that's wrong. The power of attorney is a document, but the attorney is the person who you appoint in your power of attorney to sign your name, make your decisions on money or property, manage your money or property. And you're probably going to be setting that up now for if you get to the point in the future where you can't manage things yourself, or you could be doing a power of attorney now just for some basic function that you want help with. There are, and again, we will talk more next time about the specific documents, but I'll say briefly, there are a couple different categories in powers of attorney. One is a general power of attorney who says, this person can handle all my finances, can deal with all my money or property, can sell anything, change my investments, whatever. You can also do a limited power of attorney, and it can be as limited as you want. You can decide on one specific function. They can only do that and can't do anything else. And a common thing of that is when people sell their houses. Often they'll sign a power of attorney that lets someone else go to the closing and sign the legal documents at the closing, but that's it. For estate planning purposes, we're probably looking at more of a general power of attorney that you are setting up now to provide for someone to manage your money or property at some future time when you're not able to do that. An important thing to remember with a power of attorney is that a power of attorney expires when you expire. Power of attorney ends on your death. So I'll talk about a couple other fiduciaries who can continue on after you die, but using a power of attorney, you're authorizing that person only to act as long as you are alive. Another fiduciary who can act for you during your lifetime is a healthcare agent. A healthcare agent can make your medical decisions when you're not able to make or communicate your own decisions. And I'll talk now a little about what you look for in a healthcare agent, and then we'll talk about what you look for in the other functions. So in a healthcare agent, you want someone, hopefully, who would make the same kind of decisions you would make if you were able. And you want someone to know what your values are, what decisions you would want, whether, for example, you want to continue to be kept alive artificially if you have a terminal condition, or not. Your healthcare agent will be empowered to communicate with your doctors and make those decisions. So you want someone, hopefully, who would make the same decisions that you would and who would carry out your wishes. I have a friend who says, I would never name daughter number 1 because she would never allow me to die. I want daughter number 2 because she's going to do it. Think about things like that. That's the kind of thing you need to think about. And it's also valuable if you have someone with some medical knowledge who can communicate with the doctors and understand what's going on and try to make the best decision. Another fiduciary, while you're alive, is a guardian. A guardian is appointed by a court to manage the money or property or to make specific decisions. Now, a guardianship is a rather complicated process because the court is looking out for people's interests. And for everyday issues that might require a guardianship otherwise, a power of attorney and a healthcare proxy may take care of most of the issues that a guardian would otherwise deal with. But you can, in your thinking, you can and should nominate someone to be a guardian if it gets to the point where a court has to be involved and a guardian has to be appointed. And I want to go back one thing on the healthcare agent. I should also mention another legal document is a HIPAA authorization. HIPAA is the Privacy Act that doesn't allow medical people to communicate without your permission. When you do a healthcare proxy, you're authorizing that person to communicate, but you may want to authorize other family members to communicate with doctors as well to get information. So the 3 basic fiduciary positions I talked about while you were alive, the power of attorney, healthcare proxy, guardianship. Next position can be both while you're alive and continue after you die, and that's a trustee. A trustee manages your money or property and makes decisions on how money is distributed as directed by a legal document that you sign, usually called a declaration of trust or an indenture of trust or a trust agreement. You, in your trust agreement, set up, name people to manage your property for you, and set up the rules under which they can manage that. So the trust, the declaration of trust, is a legal document. It places the legal control of your property in someone else, although it can be you while you're alive, who is a trustee, a fiduciary, and the fiduciary is acting for the benefit of the beneficiaries that you name in the trust. A trustee can be a person, can be more than one person as co-trustees. It can be a professional trustee, such as a bank or a trust company, and it can be a combination. You can name a person, a family member, and a bank, for example, as trustees. The trustee, again, manages and controls the property and has a fiduciary responsibility to do that for the benefit of the beneficiaries and with the guidance and limitations that you set up in your declaration of trust. There are different reasons for establishing trusts. One is managing money or property for someone who can't manage it for themselves. Another is maintaining control. You continue, in your trust instrument, you continue control of the property after you become disabled or after you die. The trust continues after that. And it's a way to distribute, it's a way to provide for the distribution of your property after your death without going to probate court. It is a method of avoiding probate. Trusts are also used to reduce or eliminate estate taxes after you die. Next category of trustees is only after death. So the trust can be before or after. The first category was while you're alive. After death is a personal representative. Now, a personal representative is appointed by the probate court to manage your estate after you die. This is a relatively new term in Massachusetts. You may be used to the terms executor or executrix, which was the female version, or administrator or administratrix, the female version. Those terms are no longer used in Massachusetts. Everyone is a personal representative. Used to be an executor managed an estate where there was a will, an administrator managed an estate where there was no will. Now everyone's a personal representative. The question, as you think about people, is how do you choose? I talked a little about how you choose someone to be a healthcare agent. How do you choose someone to be your attorney in fact, under a power of attorney? How do you choose someone to nominate as a guardian, to name as a trustee, or to name as the personal representative in your will? There's no right answer on this. Think about the people you know. If you're looking at family or friends, a few questions to think about. How much money or property will they be involved in managing? How complicated is it? Is this person capable of managing this type of asset, this amount of money? And are they willing? Now, your friend or family member doesn't have to do it all. They can and will work with professionals. Do you have someone who will work well with professionals, can choose professionals if necessary, or can work with the ones that you've been working with? Families, I hear, don't always get along. Can this person manage the family dynamics? Can the person handle the pressure and still treat everyone fairly, and ideally treat everyone the way you would treat them if you were still around and doing it? It's always best to have more than one choice. It's always best to have more than one choice, because sometimes people are not available for whatever reason, be it death, or they move away, or they're not willing, or they're too busy. If you're dealing with people in your generation, it's often best to have even a third choice. Or if you're dealing with something like a trust that's going to continue on for years after you die, it's best to have more choices and to think about people in the next generation. You can name one person, then a second choice, then a third choice. You can keep going. You can also name co-trustees, two to serve together, and then if one of those can't do it, fill someone else in. Other things to think about is, does this person or these people have similar values to me? Or at least do they understand my values, and would they make the kind of decisions that I would make if I were doing it myself? And for that reason, and because families don't always go together, it is often a good practice to pick two people as co-trustees or more. Trying to get people to work together who have different attitudes or who would represent the different interests. And you can also choose co-trustees with different skills. If you have one person who's really good at managing money or property and another person who's good at managing family dynamics, have the two of them work together and manage the trust or act as personal representatives together. One thing to mention is that your personal representative or your trustee, or if your power of attorney says so, which it usually would, your attorney in fact are entitled to compensation for their work. So you're not necessarily asking someone to do a lot of work for no money. They're entitled to reasonable compensation. Whoever you choose, communicate with them. Make sure they may already know your values. If they don't, make sure that you let them know what your values are. You let them know what you hope will happen. So I've talked mostly about family and friends, but there are also professional fiduciaries who can be people, banks or trust companies, who can do that. You can also designate functions. You can have the trust company be primarily responsible for investments and a family trustee be primarily responsible for the family decisions. And even if you don't make that distinction, if you're naming a family member in a bank, that will probably be the way things work out. Using a professional fiduciary will definitely add expense to the overall estate, but is often worthwhile. It's often a worthwhile expense, both to get things done right and to take the burden off family or friends. So the next thing, in addition to who manages things, is who benefits. And who benefits can be during your lifetime after you're not able to handle things yourself, and after your death. Most often, the first thing you think about is family members, and you're probably going to be thinking about how you divide things among different family members. Think about ages, health, competence, where people are in their lives. Think about providing for the different generations and for future additions to your family, grandchildren, great-grandchildren, whatever. Some people, when they start thinking, I find, immediately start strict equality. I have 3 children, a third, a third, a third. And if one of those isn't available, their kids get their third. And there's no discussion beyond that. Other people look at other factors as well, and there's no right answer on this. You may find that one branch of a family is more well off than another. One branch is particularly needy. And you may be faced with a decision. Should we go off that equality and benefit the branch that has more needs rather than the branch that already has enough? You may also find that some members of your family have more medical needs or educational needs or something like that. You may decide in your estate planning to divide things unequally to provide for that. And you may find that one branch of the family, everyone has graduated from college and you might have helped, and another branch hasn't gone to college yet. You may want to shift things around a little for that. You may also find that you're estranged from some part of your family, and you may or may not adjust for that. Again, there's no right answer on that. And sometimes people will think of someone who's been particularly helpful or particularly close and may want to give them more than others. This is for you to decide. There's no answer. You decide how to divide things among your family members if you're fortunate enough to have family members to divide things among. Other factors to look at, you may have your own children and stepchildren. Are they all going to be treated the same, or will the different sides of that family be treated differently? If you're in a second marriage and you have children from a first marriage, how do you manage things between your spouse and your other children? More questions that there are no right answers to, but things for you to think about and talk about. You should also consider whether people are going to get an outright distribution when you die or at whatever stage, or whether to have the money or property continue to be managed by someone else. Are the people who are going to benefit capable of managing this amount of money or property, or do we need a trustee or somebody to continue to manage? Obviously, young children can't manage money for their own. Teenagers probably not too. Young adults, maybe, maybe not. People with limited mental capacity, people with addiction issues. It's something for you to think about as you're deciding who benefits and also how you're going to pass on the money. Your trust can provide your trustee with the ability to make different decisions on how money is managed between different types of people. If you have an interest in a family business or a family vacation home, you may do something different with that from your other property. I've also often had people leave relatively smaller amounts of money to grandchildren or great-grandchildren. It's a good way to just be remembered. I myself benefited from relatively small amounts from an uncle and an aunt, and it was important to me that I was remembered that way. Think about that as part of what you're planning. Overall, what you're doing is considering your goals and your personal and family values and deciding what is best. I talked mostly about families, but if you don't have descendants, or if you don't want to give everything to your descendants, the same kind of considerations apply to your friends, other relatives, or other people who you might want to benefit. Or gifts to charities are a good way to continue to carry on your values after your death. And we were going to try to take a break, and I think this is the time we wanted to. So we'll give you no more than 10 minutes. Let's try to make it 5 to stretch, and then we'll come back. Was that great? Perfect. Really good.
Okay, as you're relaxing and as you're taking a break, there is so much to talk about and so much to think about. Think of questions that you may have. Remember, we're talking to 200 people here, but think about what he talked about, and this is just general in relation to getting you ready for what documents look like. But think about you, and think about questions that you might be interested in that we can discuss in the Q&A, and then where we go from here. Again, we are only as good as what we give to you. So think about it, because we're in it together, okay?
Okay, folks, if we can get resettled, we'll do part 2 after our 7th inning stretch, and then we will have questions at the end. Thank you.
And I understand some people had difficulty hearing. Is this better for the people in the back? Is this? Well, I was wearing a portable mic before, so. Okay. One thing I wanted to mention, just as a clarification, your outline says a personal representative is appointed by the probate court to manage an estate. That is true, but if you do a will, and this is one of the reasons you should do a will, is in your will you will say who you want to act as your personal representative. So it is court appointed, but it's court appointed according to your direction if you do a will. Next, I'm going to go back to, for me, first year in law school. For you, some of it may be introduction. Just a quick outline of the types of property that people own. Property is divided into 2 basic categories, real property and personal property. Real property, think real estate. Real estate is land and things attached to the land like buildings. Now, one thing that you should all be clear on here at Brooksby is at Brooksby, you do not own real estate. You don't own any interest in real estate. This is not a condominium. If you own a condominium, it may look exactly like your apartment here. You would own real estate. Here, you do not. What you own here at Brooksby is a contractual right under your residence and care agreement, and that includes the right to, with limitations, to occupy your apartment and to get your entrance deposit back. The other category, but some of you, I assume, still do own real estate elsewhere, even if you don't own any at Brooksby. So if you own real estate, continue to think about that. The other category, personal property, is divided into 2 subcategories, which you also should think about. One is intangible personal property. That's things like your money and investments. And that's obviously going to be a major part of your planning as you decide how things will be divided up. The other category of property is called tangible personal property, things you can touch. That is your clothing, your furniture, your cars, boats, airplanes, computers, valuable antiques, jewelry, family heirlooms. When you decide who's benefiting after you die, it is often really important to think about the tangible personal property as well. It may only be a small part of the monetary value of your estate, but it's often a significant part of tension within families after someone dies. Work that out the best you can now. Find out what people want. There are informal ways you can do it, such as making a list or putting stickers on things, which people sometimes do. But that is something to think about and a good way to head off potential misunderstandings. The other way you do that is when you name the personal representative in your will. One of the things, as I mentioned, you're doing is you're thinking about someone who's good at managing the family dynamics and managing possible disputes. One more thing with tangible personal property you may not think of. In Massachusetts, at least, animals are tangible personal property. Fluffy the dog, Muffy the cat, Goldie the goldfish are just like a chair as far as the law is concerned. Think about the plans for your pet as well. So those are the types of property that you're going to be looking at. Now look at the forms of ownership of that property. The first form of ownership is sole ownership. You bought this, you paid for it, it's yours, you're the only person who owns it. When you die, that passes under your will, goes according to the instructions in your will, or if you don't have a will, it goes according to what the law says, how things are divided up. I'll talk more about a will and the laws of intestacy, which is how things are divided without a will, next month. So I said property that you own individually goes through probate. To some people, that's a horrible concept and you don't want it. To others, that can be good. In Massachusetts, probate, as things changed in 2011, is not overly difficult, overly complicated. So an advantage of keeping ownership of property is individually is you continue to control it, and you can you can give it away while you're alive, or you can change your will at any time to see who gets it, as long as you're alive and competent. It will be managed under the jurisdiction of the probate court after you die, so your wishes will be carried out. So avoiding probate is often a priority, and I'll talk about that in a moment, but it's not always the only right answer. So the next methods I'll talk about are ways that would avoid probate. Another is joint ownership. Probably the most common form of joint ownership you think about is you have a joint checking account or savings account or investment account. Anything that you own jointly, when one joint owner dies, the other one becomes the owner. You take a death certificate to the bank, they take the spouse's name off the account, and it's all yours. I'll mention there's one exception to this difference, and that's by Massachusetts law, a car that's owned by one individual is considered to be joint property if that person is married. So that's the one thing you don't have to look at. If your spouse owns the car, you will get the car when they die without having to go through probate court. Other than that, joint ownership is a way to avoid probate, a way to pass on property when you die, and to do that relatively easily. But it's not always the right way. Sometimes people don't think about it when they put property in joint names. The most common situation that ends up bringing disputes in court is someone puts their son or daughter's name on their bank account, because, you know, they live in Danvers and they can pay the bills and go to the bank for them, without realizing that that means when they die, that particular son or daughter now owns all the money in that account. Courts often have to decide what people's intention is when they put joint names on property, whether the intention was that they do it for convenience, so they could pay the bills and go to the bank, or whether and in which case it is considered estate property, or whether the intention was to actually pass it on. So joint ownership can be an easy way to avoid probate and to pass on property, but you really have to pay attention. And I've had people who sometimes divide their money 3 ways and put joint names on all 3 accounts, you know, put a different kid's name on each account. You can do something like that, but do be aware of what you're doing. Do make it clear. If you do that, make sure family members know what you want. And I will sometimes, when I know that that's what has happened, put a statement in the will. If I have put my daughter's name on the account, that is for convenience, and I intend that it be part of my estate, or vice versa. So, pluses and minuses for joint ownership. It's easy, it avoids probate, but it can cause disputes in the future. There are many kinds of assets where you can designate a beneficiary now when you set things up. Life insurance, you designate the beneficiary of your life insurance. Investment accounts, often you will, investment accounts and retirement accounts, you will say who gets the money or property after you die. Some banks will do a payable on death account, which avoids that issue of the son or daughter having the joint ownership now, but still says who gets it when you die. I wanted to throw in one more thing on joint ownership, sorry. The joint owner can take all the money now while you're alive. So, another disadvantage. Now go back to trust. If you trust your son or daughter, that can be fine. Now I'm going to use the word trust in a different way. You can set up a trust. Remember, you do that in a written document, and you designate someone to control it, being a trustee. You give rules on how they control it, rules on how they can distribute it while you're alive, how they can distribute it after you die. You set up the structure now, and it continues on for as long as there's assets left in the trust. If a trust is revocable, which is the most common form that's used in estate planning, you will see a living trust or an inter vivos trust, which is Latin for during your life. You can be the trustee now while you're alive. You can manage it as long as you are willing and able, and you designate who will take over after that. If you set up a trust, you will probably be doing that through a lawyer. One of the most important things to remember is just setting up the document, setting up the structure alone isn't enough. You have to make sure that you transfer your property into your trust. You can sign the document, you can say this is what I want to happen, but if you don't move the money from your individual bank account into the trust, your individual bank account is still yours and the trust has nothing to do with it. Takeaways from today as you think about who to benefit and who to put in charge is to think about what you have now. What property do you own? In what form is it owned? Have you already named beneficiaries? And check on that. If you can't remember, check on that. What do you have in joint names? What do you have for joint bank accounts? Who have you designated as beneficiaries of life insurance? I found when my mother died that her mother had set up a life insurance policy for her when she was born. Her mother was designated as the beneficiary. Now, there are defaults in the policies that will usually work, but check on that, see who you've designated, see if it still works. Make sure your ex-spouse isn't still the beneficiary of your life insurance policy, unless that's what you want. So when you know what all your designations are, Think about whether that works, or think about whether you need to make changes. I'm going to briefly mention estate taxes and then talk about a couple specific things for you here at Brooksby Village. Estate taxes are something that is scary to people. Some people refer to them as death taxes. So I want to tell you what estate taxes are and who's going to have to deal with them, because it won't be too many people. I'm going to do it backwards. The federal estate and gift tax now applies only to people with, starting in a month, with $11.4 million. If they're married, they get to double that to $22.8 million. If you have less than the $11.4 million, you don't have to worry about estate taxes. The gift tax, the federal gift tax, is part of the estate tax, so it's a combination of what you give away during your life or what you leave behind. Massachusetts, on the other hand, does have an estate tax that affects more people. In fact, in preparing for today, I learned that it's now one of only 2 states that has an estate tax with $1 million limit. So if you leave behind more than $1 million in Massachusetts, you do have a potential for an estate tax. It is not a very high tax. If you leave exactly $1 million, the estate tax will be $36,500, which is 3.65% of what you're leaving behind. The top marginal rate in the Massachusetts estate tax is 16%. When you are doing, and again, that can be doubled if you set up things right in a trust for married. The $1 million exemption can be doubled if you set up things in the right way for a married couple. Massachusetts does not have a gift tax. Gifting can make sense, but sometimes it doesn't, because if you give away property now and pay capital gains tax, or you give away property that has capital gains, the capital gains tax is going to be higher than the 3.65% estate tax you might have to pay if you leave $1 million. Estate taxes are a lot more complicated than that, but I wanted to give you that basic introduction. Now some specific things for you here at Brooksby Village. 2 things I want to make sure that you all pay attention to. One is, for many people, for everyone here, your entrance deposit is a significant asset. And for some people here, it's probably your most significant asset. When you came here, in the midst of that confusion of selling your house and moving everything you owned and signing all those papers and paying your entrance deposit, you filled out a form. And you were given 3 choices of forms to fill out. Refund Form 1 says, I leave everything to my estate. That means that when you die, Brooksby will write a check to your estate, and it will be it will go through the probate court and follow the instructions in your will or the law if you didn't leave a will. Refund Form 2 lets you name the people who get your entrance deposit and the percentages. So that is a way of avoiding probate without having to go through setting up a trust or something like that. You designate the person or people who you want to get the entrance deposit after you die. Brooksby writes them a check. Refund Form 3 says it goes to my trust. So if you have done a trust as part of your estate planning, that's the form you fill out. You name the trust, and Brooksby will write a check to the trust. I have a homework assignment for that in a moment. The other thing at Brooksby, you just got in your mailboxes, I believe, last week. Is that right, Nancy? There's a new form that came out last week called an authorization for entry to living unit. That is an important form. If you don't fill that out, Brooksby will change the locks on your apartment after you die. We'll be back here in a month and talk more about the documents that will implement these plans. But in the meantime, I have a little homework for you. The first is to think about the things I talked about. Think about what you have that you would be leaving behind if you die. Think about who you want to benefit, who you want to get that. And it can be while you're alive and incompetent through your trust, or it can be after you die. Check on the current beneficiaries that you have named in your retirement account, your life insurance, your bank and investment accounts, your joint accounts. Check on that. See if that works with what you want, or if that should be changed. Check on which form you filled out for your Brooksby entrance deposit. And I understand Nancy checked this morning, and that is in the finance office is where they keep those. So if you can't remember and you can't find your copy, check with the finance office. I'm sure people will be glad in Thanksgiving week to go find those things. So I hope I'm not putting too much of a burden on them, but maybe wait until the week after Thanksgiving. But if you can't remember what you did, check on that and see if it's what you want. If your priority is avoiding probate, you don't want to have the form that says it goes to my estate. If you have set up a trust, you do want to make sure that it goes to the trust. Turn in your authorization for entry into the living unit form. Make sure that that your family doesn't get locked out of your apartment after your death. Talk things over with your spouse, your family, your friends. You might do that on Thanksgiving, you might not. You decide what's best in your family dynamics. But it's something to think about and talk about. So next time on December 17th, we'll look at the documents to carry out your wishes. And for now, we're open to questions on things of general interest that we have talked about, not specifics.
We will wait for microphones so that it gets duly recorded on our television so that people who watch at home will be able to hear the interchange. One note is we may not have time for all of the questions that people have, but you did get a 3x5 card, and there is a box that will be at the exit to receive cards for questions that didn't get answered, and we'll have a shot at them next time in December when Jim comes back. So with that, we've got somebody posed to ask a question.
You specified that the power of attorney can act functionally for us when we're alive. When we die, if we designate a trust, the trustee can do this, but if we don't need a trust, in other words, all our accounts are titled for transfer upon death or pay upon death, and so on. Is there the designation of the personal representative having no authority or any authority? In other words, would a bank say, no, you don't have a trust, and even though it says personal representative in your will, we're not going to honor it?
So again, the power of attorney does end on death. If you have done a transfer on death or payable on death account, that will take care of it with the bank. All the bank should need is a death certificate, and that will go to the person who you've named. So, if there's a problem, so he said he's interested in the power in case there's a problem. If there's a problem, whatever you do for estate planning, even if you have set up a trust to manage everything, you will and should do what's called a pour-over will. The will says, if there's anything in my name alone when I die, even if you think you've put everything in your trust, if there's anything left, it goes to my trust, and this is the personal representative. The personal representative will be able to deal with the bank. So the question is, you can do that without the trust. Yes, you can do that through a will by naming the personal representative in your will who will be able to deal with the bank.
Thank you. Very interesting presentation. Thank you, Mr. Peterson. All right. Okay. You were speaking about the estate tax in Massachusetts, and you mentioned that the rate was 3.65%. Does that rate change depending on anything?
Yes, it's a graduated tax, so 3.65% is what it would be with $1 million. The top rate is 16%, and that's only for the amount over 10 million. I know I had one other question earlier, and it's, so I had a specific question. Let me get to that, and you don't have to. The question was if you have set up a trust, or it would apply to a will, specifically in New Hampshire, but in any other state. What do you have to do in Massachusetts? You may or may not have to do anything. In general, a will is going to be valid if it was valid where you signed it. So if you did a will in New Hampshire before you moved here, or in New York, or wherever, it's going to be valid here as long as you don't want to change your personal representative or your beneficiaries. Same thing for a trust. So unless you want to change the people you name or the division, you may not have to redo it.
On the matter of health care agents, some folks have opted not to cause dissension in the family, and they name all the children as their agent. The lucky ones have children who agree totally on how to take care of them. However, they don't always agree. That's number one case. Number two case, they all do agree, but one of them is hidden somewhere in the Middle East and can't be found. And the person is on life support, and everyone wants to get that person off, but they can't reach the fifth person. What's your recommendations along those lines?
So my recommendation is to name healthcare agents to serve one at a time. You do your first choice, you can do a second choice, but not second choice to serve with the first choice. You make sure they know your values. You maybe do a living trust, a living will, although Massachusetts doesn't recognize those formally, to say what your wishes are, but you should only have one person at a time. You may want to do a HIPAA authorization to let doctors talk to other people, but there's only one decision maker.
If you have beneficiaries on everything that you own, your investments and everything, how important is it to have a trust?
It may not be. If you have named beneficiaries on everything that you own, that may take the place of the trust. And as long as those beneficiary designations will result in things being divided the way you want, that's an easy way to do it without doing a trust.
Thank you.
You mentioned something about a piece of paper where the law has changed and you have to make sure you have that piece of paper. What was that about now? Could you elaborate on that?
Are you talking about the entrance into your apartment after you die?
Yes.
Okay. There's a new form from Brooksby last week
really?
that you can fill out now and say who can get into your apartment after you die so that they will be let in without the locks being changed.
Has that been distributed?
Last week, right, Nancy?
Came out last week.
That was put in all of our cubbies, I believe, and if you did not get one, go to your front desk and ask for it. Authorization to allow somebody into your apartment if you die.
Could you define the term durable power of attorney?
Yes, and I almost said that, but I decided it may be a little overkill, but I'm glad you asked. Durable power of attorney just means that it continues to be effective after you become disabled. As a practical matter, every power of attorney you do now is going to be durable because a power of attorney isn't worth much if it ends when you become disabled. That was a change in Massachusetts law around 20 or 25 years ago that allowed that. It used to be that a power of attorney was only effective if you were competent, and that's not very useful. So you will see a power of attorney often with that in the title. General durable power of attorney says it's for everything. Limited durable power of attorney says it's for something specific, but they all continue after you're disabled.
Thank you.
Unless you're going to go into this more thoroughly, I'm confused about why and when probate is undesirable.
Some people consider it really undesirable. Some people consider it a good solution to things. A reason for it being undesirable, you might consider it undesirable, is that it takes a little bit of time to get a personal representative appointed, although now in Massachusetts that can often be done within about 2 weeks after death. So there's that little gap, and it involves usually paying a lawyer and paying court fees, and it makes estate planning documents public. So those are reasons to avoid probate. I gave some of the reasons that may be good. You can continue to hold on to all of your money or property while you're alive. You can change your will at any time while you're alive, change how it's going to be distributed. So,
thank you.
I have a question. If my will was made out by somebody, an attorney, who is now disbarred, do I need to make a new will?
Not necessarily. Maybe it depends on why they were disbarred. If they were disbarred because they did wills wrong, then you probably want to do a new one. But the chances are an attorney who had graduated from law school, gotten into the bar, had probably done the will correctly, even if they ran off with a client's personal injury settlement. So the answer is not necessarily.
The question has to do with access to safe deposit boxes. If you have a family member designated on your file at the bank, can they get into your safe deposit box if you die?
And the answer is yes. If with the bank you have designated them, the bank will let them in. Massachusetts does not lock safe deposit boxes when people die. If you have not designated someone, some banks, well, first of all, I will say that a safe deposit box is not necessarily a good place to keep your will, but a lot of people do keep their will, and a lot of people do keep their will in a safe deposit box. Some banks will allow a safe deposit search specifically to search for a will. They don't necessarily have to do that. So two things: don't put your will in a safe deposit box, or two, if you have a safe deposit box, have a joint owner or someone else who's authorized to access it.
I'd like to make a comment about the next to last question that was asked. I was told that you should have your will updated every 3 to 5 years. And my husband and I had done it right before we accepted an apartment here, so we had it checked again afterwards. But there are new things that keep coming up legally that you might want included in your will that hadn't been thought of before. And one of them is access to your computer, I believe.
So I actually, on access to a computer, I do a separate document which may or may not be honored, but a separate document specifically authorizing a person you name to have access to your electronically stored information after your death.
Do you suggest checking with your bank to find out if they honor a general power of attorney as opposed to a bank-specific power of attorney? I ran into that with a client.
Some banks are known to be more difficult than others in dealing with powers of attorney. I see on the elder law listserv, people have a lot of complaints about a particular bank that's very big in the country and has the word America in its name. I won't name any bank. But some banks have their own rules. For example, they won't honor a power of attorney that's more than a year old. They won't honor a power of attorney that doesn't specifically say, I authorize them to have access to my bank account, even though it says I authorize them to have access to everything. They want to see the specific bank account in there as well. So, is that enough of an answer?
But is that something you would suggest if you'd bank with a particular bank, checking that in advance, and
yes.
how long is that good for typically?
That might make sense, and you might, the person at the customer service desk might know or might not. But yes, it does make sense. And it also, when I redo any estate planning document for people, I will probably suggest that we do a power of attorney then as well, even if they have one, even if it names the same people, because now you have a new one with a new date on it. So you won't get the bank saying this is too old.
If I have a trust with a named trustee, how important is it for me to put that trustee as a joint ownership on my checking account?
It is probably not important to put that, if it's your personal checking account. First of all, if the checking account is in the name of the trust, then you don't have to because the trustee is named. If it's your individual checking account, by putting a joint name on the checking account, you're making that checking account joint property, not making it part of your trust. So when you put a person's name on your joint checking account, you're saying it's their money now, they can take it out now, and they can have it when they die, and that's probably might not be what your trust says.
As far as tangible assets, if those are the only undesignated things, does your state still go to probate?
The true technical legal answer might be yes. As a practical matter, probably not. As long as your kids aren't fighting.
Only if someone contests the issue.
Right. As long as your kids aren't fighting over the antiques or something like that, that is probably not enough reason for something to go to probate.
The question is having to do with power of attorney access for your funds. For example, U.S. government bonds. Can they be accessed with power of attorney if the person is in dementia care?
And the answer is probably yes. I haven't dealt specifically with the power of attorney on government bonds, but I do put in my powers of attorney that specific designation, so that should be enough. So yes, if the power of attorney authorizes someone to have access to your U.S. government bonds, that should work.
But if it's not specified as U.S. government bonds, it may not work.
I'm not sure. It's good to specify. It's good to specify because some people in accepting a power of attorney will require the specific paragraph saying they can do this rather than the general paragraph that says they can do everything.
Okay, thank you.
IRS is one of those also that I guess IRS requires a specification in the document.
I have a question about the checking accounts, having an individual on the checking account, a second individual on the checking account. And I was trying to compare what the financial advisor, the lawyer, and the bank were saying, and the bank would strongly advise against it. And the argument was that anything in a checking account avoids probate unless the amount is over $10,000. At under $10,000, there's no probate anyway. It wasn't clear to me whether that applied to individual accounts or to the total amount with the particular bank.
So there is a specific Massachusetts law, and I can't remember the dollar amount. If the bank told you 10, maybe that's it. I thought it was 6. There's a specific law that says that a bank can allow bank accounts to be transferred without probate if they're under a certain amount and follow some other rules.
And would you expect that that would be the total within all of your checking accounts within the bank, or to each
Yes.
individual one?
Yes, not each individual. So you would be looking at the total, yes. So,
Can your checking account come under your trust?
yes. So if you have established a trust, you can put the money in your bank account in the trust. Sometimes for convenience, people will keep a small amount in their own name separate from the trust and put most of the assets in the trust. That way, if people still write checks in the supermarket, you don't have to sign as a trustee on your check for your groceries.
I think we have time for one last question, and then Jim may want to just remind us of our homework assignment before we applaud and adjourn. And one other thing, if you had a question that you didn't want to say out loud, you can use your 3x5 card and put it in the box, which we're going to move to the table outside the doors. So we are still collecting questions if you want to. So time for one last question.
Okay, I have one question. If you draw up a trust, and the trust, say you have some investments in the trust, so there's some income, which state would, and the trustee moves to a different state, which state would you pay taxes to, where the trust was drawn up or to where the main trustee resides?
Taxes aren't my best thing, but in general, it's where the trust assets are located. So if you have done the trust here and the assets are here, where the trustee resides doesn't matter. Where the assets are is what matters.
I will say that last question sounds almost like a law exam that I remember from many, many years ago. And the law student would say, well, I'd want to research that. That would be part of the answer on your exam. So there are some situations that are complicated that require individual answers. And so with that, I want to thank everyone who helped organize this program, and to the microphone carriers who helped us communicate, and the folks back home. I will give Jim one word for our homework, and then let's give him a big round of applause.
So I also want to thank the people who organized this, and I'll remind you of your homework, but it's on your handout as well. You're going to think about what you have. You're going to think about where you want it to go, who you want to benefit. You're going to check what you have now in terms of your beneficiary designations and think about whether that should be changed. You're going to think about who you want to handle things, your fiduciaries. You're all going to remember that word. And 2 specific Brooksby things. You're going to find it in your mailbox and turn in your authorization for entry to living unit form, and you're going to find out who you have designated to get your entrance deposit after you die.
Thank you so much, Jim. This was really great. Now we're in it together, and we can talk to each other about what's puzzling us. Thanks. Bye.